This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Provided that upon appointment he or she shall mandatorily undergo breach course recognized by NCT within 2 years of such appointment as primary teacher. Challenging such notification of NCTE, several writ petitions were filed in different high courts throughout India. The Honorable Rajasthan High Court was the first court to set aside the said notification of NCTE. The aforesaid order of the Rajasthan High Court was assailed before the Honorable Supreme Court in SLPC within bracket C 20743 of 2021 ব্র্যাকেটে লিখুন দেবেশ শর্মা ভি লিখবে না দেবেশ শর্মা ভার্সেস ইউনিয়ন অফ ইন্ডিয়া In the meantime, the WBBPE issued a notification for conducting TET 2022. দেখুন তো আরেকটা ফাইল আছে যাতে জাজমেন্টস গুলো দেওয়া আছে issued a notification being number 1572 slash WBBPE slash 2022. What is the date of this notification for conducting the TET 2022?
22nd of September 2022.
Dated 22nd September 2022. একটু আন্ডারলাইন করে রাখুন
22
চেক করুন
না 22 নোটিফিকেশন হচ্ছে 29 সেপ্টেম্বর
29 September 2022.
নোটিফিকেশন
নোটিফিকেশন ডেটই জানতে মানে সেম ডেট তো যেদিন একটা রিক্রুটমেন্টের নোটিফিকেশন হবে
notifying that the board is going to hold TET 2022 for qualified trained candidates including B.Ed candidates of West Bengal seeking appointment to the post of assistant teacher in government aided / sponsored / junior basic primary schools. The said notification was assailed by some of the BLED candidates before this honorable court in WPA number 23-202 of 2022 within bracket Ujjwal Haldar and others versus Union of India and others. The said writ petition was disposed of, directing that the candidature of B.Ed qualified candidate shall abide by the result of pending special leave petition, special is the capital word, na? Special leave petition before the Honorable Supreme Court in Devesh Sharma versus Union of India. Disposed of on না দেবেশ শর্মাতে না, এটা ডিসপোজড হয়েছে রায় সাহেবের অর্ডারে। এটা ডেটটা দেখে না। Including the fate of the present petitioners, whose eligibility was covered by the notification of NCT dated 28th June 2018. The board has also issued notification being number 1770/WBBPE/2022 notifying that the candidates having B.Ed qualification will be allowed to apply for and appear in TET 2022 subject to the final result of SLPC number 20743 of 2021 pending before the Honorable Supreme Court. By its judgment dated 11th August 2023, the Honorable Supreme Court was pleased to set aside, affirm the order of the Honorable Rajasthan High Court and set aside the notification being F number NCTE-REGL 012/16/2018 dated 28th June 2018. Thereby holding that the B.Ed is not a requisite qualification for teachers for primary school and that the central government has acted against the constitution and the laws. The effect of the said judgment of the Honorable Supreme Court is retrospective, meaning thereby that the petitioners who qualified in TET 2022 with B.Ed qualification cannot be treated to be valid upon setting aside of notification dated 28th June 2018. Some of the candidates who were already appointed as teachers in primary school in the state of Madhya Pradesh filed a miscellaneous application before the Honorable Supreme Court seeking to give prospective effect to the judgment. Upon hearing, the Honorable Apex Court protected only those candidates who were already appointed and none else. To buttress his contention, he relies on decision of Honorable Supreme Court in Devesh Sharma versus Union of India reported in Suprana citation টা দিতে হবে এখানে। Reported in 2023 volume 18 SCC 339, as well as the clarification order passed subsequently reported in 2024 SCC online SC 3096. He also indicates that the added respondent and others preferred a writ petition before this honorable court for praying inter alia for cancellation of TET 2022 results, as well as certificates issued in favor of the candidates who appeared in TET 2022 with their B.Ed qualification. In terms of notification dated 29 September 2022. Can you, who is it? Can you place that order of Justice Mantha?
Yes, madam.
The interim order and the final order. Final order means the interim order being made absolute.
Start with 156 and 160.
Order 2022.
The Honorable Court was pleased to pass order. What is one? Pass order not to process recruitment for the post of assistant teachers for 2022 candidates with B.Ed qualification or DLED within bracket NIOS qualification under WBBPE. Talk. The said order has been made absolute till the disposal of the said writ petition. Thus, the petitioners with state 2022 qualification, state 2022 qualified with B.Ed degree are not eligible to appear in the ongoing recruitment process. Deal. Mr. Piyush Chaturvedi, learned senior advocate appearing for added respondent numbers 10 to 15. Adopting the submission of Mr. Sannal, learned senior advocate for WBPE, indicates that with the passing of the order in Devesh Sharma Supra, the notification dated 28 June 2018 has become non-existent or void ab initio, that is, from the very beginning. By the clarificatory order passed in Devesh Sharma Supra, only candidates who were already been appointed was protected and none else. Orders have been passed in earlier writ petition where the fate of the candidates who qualified in TET 22 was subjected to the decision rendered in Devesh Sharma Supra. No appeal has been preferred against the said order. Notice has also been issued by the board notifying the fate of the candidates of TET 2022 to be subjected to the result in Devesh Sharma Supra. Thus, the petitioners who claims to be TET qualified is upon decision Devesh Sharma is not eligible to appear or participate in the ongoing recruitment process. In reply to such contentions raised on behalf of the board, respondent board, as well as added response number 10 to 15, Mr. Ahmed, learned advocate for the petitioner, referring to paragraph number 80 of the decision in Devesh Sharma Supra, submits that the B.Ed qualification which was introduced as per statutory notification of NCTE is valid till it is declared illegal or unconstitutional by the court. Even if the board is of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. Therefore, the candidates who qualified in TET 2022 are valid candidates till the decision was rendered in Devesh Sharma Supra, declaring such notification of NCTS as unconstitutional. Furthermore, referring to paragraph 81 of Devesh Sharma Supra and relying on the decision of Honorable Supreme Court in State of Manipur versus Surya Kumar Okram, reported in 2022, Volume 9 SC Seat 723, he submits that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. In declaration of the law, the doctrine of prospective overruling is applicable. Therefore, thus, such a declaration rendered in Devesh Sharma Supra can never have retrospective effect, for which reason the Honorable Supreme Court has protected the candidates who were already appointed as primary teachers. Stop. In the same breath, the petitioner's qualification of TATE 22 needs to be protected. He further indicates that TATE and recruitment process are distinct and different. Needless to mention that the certificate of TATE 22 has not yet been recalled or cancelled by the board. Therefore, the board in no way can challenge the validity of the candidates who succeeded in TATE 2022. Para. There cannot be, it is not in dispute that the petitioners before this court have passed TATE 2022 and all have been issued certificates
Yes.
and all have been issued certificate to that effect. The TATE 2022 was conducted allowing the candidates with B.Ed qualification on the basis of the notification of NCTE dated 28th June 2018. Para. For better appreciation, the said notification is reproduced here under. Notification. দেবের শর্মা
এটাই তো।
করা আছে।
কোনটা তাই? 104 104 in the writ petition. আমাদের writ
Take it
টা
from দেবের শর্মা। এই দেবের শর্মা এই কোডটা নিয়ে নিন, পেজ 26।
একশো 107
এটা কোড করবেন এখানে। Thus, by dint of the aforesaid notification, B.Ed qualification, Bachelor of Education with a B.Ed qualification was included for appointment of assistant teachers in the primary schools. The aforesaid notification was the aforesaid notification was set aside by the Honorable Rajasthan High Court in Rajendra Singh Chotia versus NCTE reported in its 2021 SCC online Rajasthan Raj 4372. The said order of the Honorable Rajasthan High Court was assailed in appeal before the Honorable Supreme Court in SLP number to the along with other writ petitions 20743 of 2021. The Honorable Apex Court in paragraph number 63 held as follows. 63 set out. Thus, by the judgment in Debesh Sharma Sutra, the notification of NCTE allowing B.Ed qualification as a requisite qualification for appointment of assistant teachers of primary school was set aside. Para. Needless to mention that the TET 2022 qualification, TET 2022, needless to mention that the notification of the board WBPP for holding TET 2022 was assailed before this honorable court in WPA number 23202 of 2022, Ujjwal Haldar and others versus Union of India and others. The said writ petition was disposed of on 18th November. Give that order.
18th October.
18th October. October 2022 as follows. Are you considering? Okay. This has been annexed to the writ petition or can application? Can application. Which is the page number? Right.
143.
Are you considering? Pursuant thereto, sorry, একটা লাইন ওখানে অ্যাড করব. Thus, the fate of state 2022 candidates were subject to the special leave petition in Devesh Sharma Supra. Result of the special leave petition in Devesh Sharma Supra. On 7th November 2022, the board issued a notification notifying that all the steps taken and to be taken in terms of notification number 1572 slash WBBPE slash 2022 dated 29th September 2022 by which the date 2022 was to be conducted shall abide by the result of SLPC 20743 of 2022 bracket the year has been wrongly typed. Therefore, there cannot be any quarrel that the fate of TET 2022 was subjected to result in Devesh Sharma Supra. Mr. Ahmed has strenuously argued that Mr. Ahmed, learned advocate for the petitioner, has strenuously argued that the effect of the decision of Honorable Supreme Court in Devesh Sharma Supra is to act retrospectively, to act prospectively, and not retrospectively. Verificatory order. In order to examine the argument as advanced on behalf of the petitioner as aforesaid, it would be apposite to reproduce the clarificatory order passed in miscellaneous application in Devesh Sharma Supra. In given fact এখান থেকে নিয়ে এসে এই অবধি in view of the aforesaid, it is found that the Honorable Supreme Court has categorically held that ordinarily a judgment acts retrospectively unless it is specifically stated to be otherwise. It has further been clarified that that the benefit has been extended only for the candidates who were appointed prior to date of the judgment, that is 11th August 2023. It has also been held that mere selection of such candidates or their participation in the process will not entitle them for a benefit under the present order. Um, Mr. Ahmed has relied on Surya Kumar Okram Supra to impress upon the court that the order in Devesh Sharma has a prospective effect. Following proposition were laid down by Honorable Supreme Court in Golaknath. এই দেখো paragraph 33. Hmm. $33 and $34. হ্যাঁ গোলকনাথ আছে 14 আমি বলে দিচ্ছি দাঁড়ান 14 বলে দিলেন কোথায় খুঁজবেন গোলকনাথ হচ্ছে 1967 SCC online SC 14. The proposition as laid down in Goloknath has been followed by the Honorable Apex Court in Suraj Kumar Okram, and it clearly lays down that the doctrine of prospective overruling can be applied by the Honorable Supreme Court and the relief can be molded by the Honorable Court in exercise of its power under Article 142 of the Constitution. For such reason, the argument advanced on behalf of the petitioner is not sustainable. In view of the above discussion, since the notification as set aside in Devesh Sharma Supra has become non-existent, therefore, the eligibility of the TATE 2022 qualified candidates to participate in the ongoing recruitment process is questionable, rather to hold that they are not eligible to participate on the basis of state 2022 qualification. It will not be out of place to reproduce the orders passed in a writ petition being WPA 2661 of 2024, wherein the petitioners have sought for cancellation of the results of state 2022 and the certificate issued thereupon. এটা কোট করবেন।
One 156 বার
156 না 155 এর আগে অর্ডার নেবেন 12 নম্বর এবং 156 এর 159 এর প্যারা 16 কেমন এটা কোয়েশ্চেন তো নিয়ে চলে গেল। Next questionটা কি next issue number 2 করে দিন question whether the pursuing candidates are whose results are awaited can appear. Mr. Ahmed, learned advocate for the petitioner, submits that the petitioners have completed their DLED course and the final exams have also been conducted by the board. However, the results have not been declared. Relying on Soumen Pal and others versus Stravoni Naik and others, he submits that since Rule 6(2) of the West Bengal Board of West Bengal Primary School Teachers Recruitment Rules 2016 does not provide any cutoff date to obtain the qualification. The qualification on the last date appointed for receipt of application is to be considered. If the board publishes the results it will definitely allow the petitioners to participate in the ongoing recruitment process. referring to para করুন Mr. Channal and its senior advocate appearing for WBPE submits that as per the আচ্ছা ওই উপরে একটা রুল বললাম না ওয়েস্ট বেঙ্গল টিচার্স রিক্রুটমেন্ট রুলস ব্র্যাকেট করুন হিয়ারিন আফটার রেফার টু অ্যাজ দি রিক্রুটমেন্ট রুলস 2016 referring to rule 6(2) of the recruitment rules 2016 as well as amended as well as recruitment notification dated 25th September 2025 he submits that the provisions and the advertisement is unambiguous that the candidate must have passed 2 years DLED on the date of advertisement. Since the petitioners do not possess the said qualification on the date of advertisement for recruitment, they are ineligible to be taken into zone of consideration. The results, he informs the court that the final exam has been conducted only on 15th November 2025. The board requires a reasonable time to publish the results. In similar circumstances, this court in earlier writ petitions have turned down such prayer in support of his contention. He relies on the decision of this court passed in Koeli Chakraborty and ORS others versus State of West Bengal and others, and one other writ petition reported in 2017 SCC Online Calcutta 356. Further, relying on the decision of Honorable Supreme Court passed in Tej Prakash Pathak versus Rajasthan High Court, reported in 2025 2 SCC 1, he submits that the rules of the game must not be changed midway. ঠিক আছে? Or after the game has been played. Stop. Once the recruitment process commences, the rules cannot be changed thereafter. As on the date of advertisement, the petitioners did not possess the required qualification. The requirement cannot be changed or molded by allowing the petitioners to participate in the recruitment process who are till date pursuing the course since the final results are awaited. আচ্ছা ওপরে না ওই মিস্টার আহমেদের সাবমিশনে একটা জায়গা শেষে আবার নিন একটা পয়েন্ট he also indicates that referring to the supplementary affidavit, he indicates that some of the candidates with who have qualified TATE 2022 has been allowed by the board to participate in the recruitment process. এটা এই পোর্শনটা না ব্র্যাকেট দিয়ে ওপরে দিয়ে দেবেন, ওপরে যেখানে টেট 2022 এর এটা করেছিল ইস্যু নাম্বার 1 এ এই পোর্শনটা ওখানে চলে যাবে।
মানে only one indulgence মানে qualified TATE 2022 with B.Ed degree মানে this need to be
with B.Ed degree। এই যে সাপ্লিমেন্টারিটা পাচ্ছি না গো। হ্যাঁ দেবনাথ বাবু,
সাপ্লিমেন্টারি করছি এই সাপ্লিমেন্টারিটা
you have got a copy of the supplementary, please। ওটার আনসার হ্যাঁ ওটা বলছে তো have been allowed, to which Mr. Sannal has informs the court, informs the court that though such application has been accepted, but it is the view of the board not to allow any candidate of TATE 2022 qualified with B.Ed। কোথায় ছিলাম ওখানে চলে আসুন।
My lord, we have referred another documents, my lord, a report filed by them in the coordinate bench, my lord, where the secretary of the board informed the court that
yes
yes
ওই রিপোর্টটা কোথায় রাখবেন, ওইখানে উপরেই। He has also placed reliance on the report filed by the board in WPA 5122 of 2024 within brackets Subhrangshu Pathak and others versus the state of West Bengal and others, wherein he submits that the board has considered that the candidates passed in TATE 2022 with B.Ed training qualification may be considered as TATE 2022 passed candidates, since the candidates were already declared as TATE 2022 passed candidates. Mr. Sannal, in reply, has clarified that the board has stated before the court in such report that although TATE 2022 has been shown to be qualified, but that is subject to the solemn order of the Honorable Supreme Court in Devesh Sharma Supra। এবারে চলে আসুন, এটা কি ছিল কোয়েশ্চেনটা, হ্যাবিটিং না এটা ওনারটা না, এটা ওনার কথা।
Damar.
Mr. Piyush Chaturvedi, learned senior advocate appearing for the added respond numbers 10 to 15. Submits that the petitioners have not yet passed DLED. As per the notification, the petitioners, the candidates who have passed DLED on the date of advertisement can apply. Relying on the decision of Honorable Supreme Court reported in 2025, Honorable Supreme Court in Porimal Kumar and others versus State of Jharkhand and others, he submits that 25(1) SCR 1953, he submits that the rule of the game cannot be molded once the recruitment process is initiated. In order to assess the issue under reference, it would be profitable to reproduce Rule 6(2) as hereunder. Rule 6(2) টা কোথায় পাবেন? সৌমেনে পাবেন। এটা লাগবে। প্যারাগ্রাফ 3 তে আছে। এই যে 2টা, হ্যাঁ। The aforesaid rule provides that the candidates shall possess the minimum educational and training qualification as prescribed by National Council for Teachers Education prevailing as on date of publication of recruitment. In Soumen Pal Supra, the Honorable Court, Apex Court, has considered the provision and has observed that to ensure that the latest prescription of NCT should be made applicable for any recruitment, the rule also provides that qualification prescribed by the NCTE within inverted comma prevailing as on date of publication of recruitment notification must be possessed by the candidate. It further observed The intendment of Rule 6.2 of Recruitment Rules 2016 is only to declare that qualifications as prescribed by NCT and that are prevailing on the date of publication of the recruitment notification should be possessed by the candidate. The Rule 6.2 as well as the notification issued by the board goes to show that the candidates should possess the requisite qualification on the date of publication of the advertisement. It is pertinent to note that in Somen Pal Supra, the notification of the board allowed the pursuing candidates of DLED to take part in the recruitment process, which is quite distinct from the present notification, which in unambiguous term in 3B of the advertisement clearly stipulates that the candidates who have passed would be allowed to take part in the recruitment process. Furthermore, this court finds substance in submissions of Mr. Chaturvedi and Mr. Sannal and Mr. Chaturvedi, senior advocates, that the rule of the game cannot be changed as held by the Honorable Supreme Court in Tej Pratap Supra. Therefore, a pursuing candidate cannot be, whose results are awaited, cannot be allowed to participate in the recruitment process, which has already been initiated with a notification dated 25th September 2025, read with notification dated 9th November 2025. আচ্ছা তেজ প্রতাপটা না একটু এই জাজমেন্ট থেকে কোট করবেন তো এই যে দেখুন তেজ প্রতাপের 53 54 দাগ দিয়ে দিন 54 তেজ প্রতাপের মানে না এটা হচ্ছে এই জাজমেন্ট ওই পরিমল কুমার যে জাজমেন্টটা আছে তার 53 আর 54 টাকে কোট করবেন তেজ প্রতাপ নিয়ে এসছে The position of law as per Tej Prakash Pratap Supra is therefore clear that the recruitment process commences from the issuance of advertisement and that eligibility criteria as laid down therein cannot be changed midway during the recruitment process unless the extent of rules or the advertisement permits such a change after issuance. Even if such power to amend is reserved in the advertisement or the rules, it must be tested on the anvil of Article 14 and pass the test of non-arbitrariness. Objection. Next question. Three. Whether there was any intentional and deliberate laches on the part of the board to publish the results of DLED. The petitioners have taken admission in course, DLED course, 2 years DLED, 2-year DLED course of 2023 and 2025. It is not in dispute that after completion of the course, the petitioners have appeared in the final examination only on 15th November 2025. Therefore, reasonable time is required for assessment of the candidates. In view of the above, taking the date of final examination in mind, this court is of the view that there is no such laches on the part of the board in not publishing the results. However, this court deems fit that the results of DLED, 2-year DLED course, be published as expeditiously as possible. Next issue. Next issue. Whether there is any suppression of material facts. Mr. Channal Lanet, senior advocate appearing for the board, submits that previously some of the petitioners arrayed in the present writ petition has filed an earlier writ petition wherein they have prayed for updation of the data and for considering the DLED degree holder valid candidates to appear in primary teacher recruitment process conducted by the authority. The said aspect has been suppressed in the present writ petition. The petitioners can only seek equity if material truths are disclosed before the court. When a party suppresses facts or makes false statements, the court cannot permit to use its process for such a purpose. Entertaining the matter full stop there. Entertaining the matters on merits in such circumstances would amount to encouraging dishonest conduct. A litigant who seeks relief must show respect for the truth. When he when he does not do so, ওই যে এ হয়ে গেল একটা করিনি না, ট্রুথ অফ দি উনি করেছে, ঠিক আছে? When he does not do so, he cannot expect the court to exercise discretion in his favor. To buttress his contention, he relies on the decision of Honorable Bombay High Court in Ram Rao Tukaram Patil and others versus State of Maharashtra. Through Secretary Department of Cooperation and others, along with one other writ petition reported in 2025 SCC Online, Bombay, 4462. In reply to such contention, Mr. Ahmed, learned advocate for the petitioner, submits that the cause of action of both the writ petition are distinct and different. Therefore, there is no deliberate suppression of material facts before this court. There cannot be any quarrel that some of the petitioners who are, have you made the serial numbers?
No. They have only given a number, but they have not given the serial number.
How many candidates are there?
They have alleged that 67.
113
113.
Serial number গুলো দিয়েছিস?
না না লিখে এনেছিলাম তো দিয়ে দাও।
এটা মনে প্রথমত 62. Mr. Shanal said 62.
62.
113 লাস্টে বলেছি।
About Sir Ahmed, will you kindly check and then report to my court officer how many are there?
Because they are saying so, Lord, I don't have that writ petition. Let the
Then
board.
you check it with Mr. Ahmed and provide the number.
Right.
Okay.
I'll
Some of the candidates করে dash দিয়ে দিন, ওখানে numbers টা দিয়ে দেন। Have
Ratul at a combination.
filed the writ petition, earlier writ petition being WPA 10942 of 2025, wherein a direction has been sought upon the respondent authorities to update and or alter teacher training data of petitioner in West Bengal Board of Primary Education database and certify in this regard, and also to take necessary steps so that the petitioners can be considered as DLED degree holder valid candidates to appear in the primary teachers recruitment process conducted by the authority. The aforesaid writ petition has not been disclosed in the present writ petition. This court is of the view that such aspect ought to have been disclosed in the present writ petition. In view of the above discussion, this writ petition falls short of merit. Dismissed. Sorry. Next again.
Obliged.
Thank you, Mr.
সাত দিনের স্টে দেখুন।
Lord, may I just indicate one thing, since your lordship has already discussed the date part, but Lord, may I pray stay on those aspect, Lord. So for the date part is concerned.
No, no.
Obliged.